Assalamualaikum and very good evening. Today we from Group 1 will present about the current issues on property in Malaysia, case study in Shariah Court. This is our group members. First, it's me, Nur Amni Ilyati binti Ismadi. Second, Cik Wan Farah Ayuni binti Cik Wan Nur Maudin. Third, Siti Husna Shifa binti Mio Hijdayat. And last, Nur Idayu Syafiqah binti Abdul Halim.
Assalamualaikum everyone. I'm Siti Husna Shifa and now I will start the presentation due to the topic of current issues on property in Malaysia based on the case study in Shariah Court. First of all, what do you know about the property? Actually, there are various meaning of property that I found. But now I just share with you the three of them. So the first one is, the property can be defined as an object that belong to someone, possession collectively. It means the property has its owner itself. Next, property also can be described as the legal right to own and use something. The individual owns the property and he can use it anytime and anywhere he wants. And the last one is, rather than an item, the property also can be described as a building or area of land that someone owns. And then we move to the difference between Shariah Court and Civil Court. I do like this so it can be more clear to see the difference between of them. Alright, so we start with the Shariah Court. Shariah Court is limited jurisdiction over matters of state Islamic law. But the Civil Court no connection to any religious belief. The second one is, Shariah Court deals with the members of the Islamic religion only, while Civil Court deals with everyone regardless of race and religions. And the last one is, Shariah Court have a jurisdiction in adoption, marriage, divorce, living beliefs, business dealings, and more, while the Civil Court have jurisdiction in accidents, property, ownership, family issues, and more. So, to be concluded, the Shariah Court is focused on the Islamic religion and members. Okay, now we start with the first subtopic, which is hibah. As we all know, hibah is one of the type of grant or a gift. The long meaning of hibah is a gift on the basis of love without any return made by the giver to the recipient of the hibah while he is still alive. Islam also defines hibah as the granting ownership of property from one party to another without any consideration, which is iwat, occurs during the life of a hibah provider, made voluntary, not meant to glorify anybody, and given by reciting an ijab and qabul or any such expression. Okay, let's see with the requirements and condition of hibah. There are 4 conditions that the hibah can be accepted. So the first one is the provider, which is al-wahib. The second one is recipient or al-mawhub lahu. The third one is the asset itself, al-mawhub, and the last one is sirah, which is ijab qabul. There are some opinion from the scholars on withdraw a hibah. So let's see the first perspective from Hanafi scholars. It says that makruh to withdraw hibah that have been given away. While the perspective from Shafi'i, Hanbali, and Maliki scholars, it says that hibah cannot be withdrawn unless the hibah is made by immediate family to the children for as long as the property is not related to other people. So if the recipient of hibah was give or share the property to the others, so it cannot be withdrawn even though made from the immediate family. So actually it is inappropriate to take back what we give to the others, because there's one hadith says that one who get back his gift is like a dog which vomits and then swallows that vomits. Riwayah Al-Bukhari and Muslim. In Shariah Court, there are some cases that be handled related to a hibah. So the first cases is about the withdrawal or revocation of hibah. In this case, this one man, which is the giver, had a piece of land that transferred to his adopted son. One day, he changed his mind to let the land to be transferred back to him. But his son had developed the land and constructed several buildings on it. The value, or which is the buildings, was inseparable from the subject matter of hibah, which is the land. So this is also one of the conditions that the hibah cannot be returned back to the giver. So since both of them had complied with all the conditions, which is they have the giver, the recipient, the asset, and also sigah, so it was held that the transfer here represented as a hibah. So the court have been decided that the giver could no longer retract the gift and demand for its return. One of the major issues highlighted on hibah is the dissatisfaction by beneficiaries on hibah. This is one of the most reason the beneficiaries file the cases in Shariah court, especially the family members. As we can see, the data result shows that there are an increased number of cases registered in Malacca Shariah Court from 2013 to 2015, which is from 12 number of cases to 31 number of cases. So actually, why is this happen? It is because the poor understanding, lack of knowledge and awareness on the practice of hibah. Actually, in our culture, some of us do not focus on the practice of hibah because we always let the property to be handled in faraid way. But actually, hibah is one of the effective way to divide the property to the other family members. Right, so this problem actually can lead to dispute among related parties and also lead to a substantial number of crime cases. Alright, for the next case was about the verification of hibah, which is someone who want to verify whether the hibah was accepted or not. So in this case, the donor had debt and there was no withdrawal of hibah, so it's safe. But the problem is the building in dispute still bore under the name of the deceased, although the hibah had been witnessed by others. So the receiver declared that he has been received the rental or the lease of the dispute building since the deceased was still alive. Okay, so it means they complete all the condition of hibah contract. So the Terengganu Shariah Appeal Court accepted the appeal made by the petitioners based on the accepted qarina, which is evidence from the receiver. So the conclusion is the hibah was accepted since all the conditions have been made.
Thank you for the first presenter. Now I will continue the presentation with my topic, which is inheritance. First of all, we need to know what is inheritance. Inheritance is the property left by the deceased to be inherited by his family members. And the management and administration of Muslim inheritance in Malaysia is distributed to three major agencies, which are High Court, Small Estate Distribution Section under the Department of Land and Mines, and the Amanah Raya Berhad. There are many types of inheritance, which are small estate, brief estate, intestate estate, and testamentary estate. But today, we will not focus on the type of inheritance, but we will focus on the issue of inheritance. One of the issues is procedural inconsistencies. Agency diversity in estate management has led to procedural inconsistencies. This issue will cause confusion among the heirs and it will slow down the process of division of the estate among them. This often happens when other agencies want to interfere with the work of Shariah Court and cause different decisions to be received. This situation will also cause confusion which can lead to dispute between the heirs or other parties involved. And it will be even more complicated when family members are less skilled in the field related to this estate will. In this case, the determination of the estate should be the duty of the Shariah court because the judges of the Shariah court are more knowledgeable in administering the estate. Therefore, dispute between heirs can be avoided. Lastly, we as Muslims need to studying and understanding these signs can be seen in the hadith of the Prophet Muhammad sallallahu alaihi wasallam, which means learn the knowledge of faraid and teach it to human. Indeed, it is a part knowledge and it will be forgotten as well as that knowledge, the first to be lifted up from my people.
Thank you to the second presenter. Right now, I will continue this presentation with my topic, the current property zakat. What is zakat in Islam? Zakat is a form of finance in Islam that is obligatory on an individual who is qualified to donate certain property every year for the purpose of charity. There are many benefits we can take from zakat. First, zakat be able to clean access property and fertilize the property. Second, those who can afford it have the opportunity to worship by issuing property in zakat. And last, reducing feelings of envy among the less fortunate. Then we will look how to read of zakat charge. Zakat rate will be calculated based on income and property value. The minimum rate is 2.5% or only 1/40 of the property cap and wealth owned. Current issues that we can relate to zakat. Distribution of zakat itself. According to the jurists, zakat is not an individual matter because zakat is about responsibility and has government intervention through the treasury and other agencies to facilitate the management of zakat. Based on the view of fuqaha as well, the government has the power to collect zakat from external assets, and when asked to pay zakat, then the people are obliged to pay it. Zakat management has become more systematic and managed with the existence of amil institutions such as Baitul Mal and zakat collection centers. The property does not matter whether it is internal or external, but its management is subject to the government based on clear guidelines in the relevant text. This view is also agreed by some other scholars such as Sheikh Abdul Wahab Khalaf, Sheikh Abdul Rahman Hassan, and Sheikh Muhammad Abu Zuhra. In the issue of zakat distribution itself, a problem has also arisen where if the zakat giver gives zakat to non-asnaf who are entitled, the party who wants to give this zakat should first check the name of the eligible recipient with the state zakat management and state the matter to the appointed amil before making his own distribution. Second current issues we can relate to zakat is giving zakat to non-Muslim. The issue of giving zakat to non-Muslim is a matter that is categorized in the matter of khilafiyah, difference of opinion. There are a few scholars who think that giving zakat to non-Muslim is not permissible. According to Imam Shafi'i, these non-Muslim are not allowed to receive zakat. We refer on what he says in his book. The convert whose hearts are dim are those who enter Islam. No sadaqah, zakat is given to the polities to tempt them with Islam. The figures who adhere to the Shafi'i school, such as Imam Nawawi in Al-Majmu', also stress the same thing. Factors of poverty and destitution are not a reason to allow non-Muslims to receive zakat due to the basic fact that they do not embrace Islam. However, there are scholars who differ with the opinion of Imam Shafi'i. Zakat is given to them who is non-Muslim to soften their hearts toward Islam, or referred to as al-mu'allafah qulubuhum.
Now, let's move to the next issue, which is matrimonial property division. So, what is matrimonial property division? Matrimonial property division matrimonial property is the property that is obtained through joint effort by husband and wife during their marriage, effective according to the requirements set by Shariah law. Matrimonial property includes money, movable property, immovable property, or any assets acquired jointly during the marriage period. According to Section 2, Islamic Family Law, Enactment 2003, matrimonial property is defined as property that is acquired jointly by husband and wife during their marriage, effective according to the requirements set by the Islamic law. Applying for the claims of matrimonial property can be made at the Shariah court in three different conditions, which are after divorce, during marriage, and after death. For claim after divorce, Section 1 to 2 of the Islamic Family Law, Enactment 2003, for example, has provision that the court has the authority to order the distribution matrimonial property when the court allowed the divorce statement or divorce order. Therefore, the court with the authority for matrimonial property cases has to be in the same state where the divorce took place and registered. Islam acknowledges every individual rights to own property. Each individual, including husband and wife, is entitled to own any property, as the bond of Islamic marriage does not nullify or limit their right. The religion sees matrimonial property as a way to acknowledge the property owned by someone based on their efforts to own it. Allah Subhanahu wa Ta'ala has said in Surah An-Nisa, verse 32, it means, and do not wish for that by which Allah has made some of you to make them exceed others regarding property, knowledge, or power. This is because for men is a share of what they have earned, and for women is a share of what they have earned and strive, and ask Allah of His bounty. Indeed, Allah is ever of all things knowing. So, what happened to the matrimonial property after divorce? So, this is the proportion of share during the process of matrimonial property division. Section 1 to 2 of Islamic Family Law Enactment requires the court to determine the parties' share, to examine the extent of direct contribution made by a spouse in terms of work, money, and capital. In connection with this contribution, the entitlement of a spouse from this contribution is equal. For spouses who have not made any direct contributions, the entitlement of a homemaker wife arises from her indirect contribution in taking care of the welfare of the family. On the other hand, the basis of determining the proportion of matrimonial asset is ascertained by assessing the actual contribution made by the parties directly or indirectly. The court, in deciding the division, literally follows the provision where the extent of contribution, either direct or indirect, is a sole criteria in determining the proportion. In relation to that, the court regards monetary contribution of the spouse to acquisition of asset as preference and significant rather than a homemaker's non-financial contribution. The court does not hesitate to incline the equal division when the quantum of percentage of monetary contribution is determined and definite in the equal division of joint assets. However, in several cases when there was disparity in financial proportion between the spouse and in the contribution made, the court is likely to incline towards equal division. A study shows that practically 1/3 proportion is an appropriate entitlement for a homemaker wife based on her homemaking contributions in the division of sole effort assets. It has been observed that this is practiced in most states throughout Malaysia. So what is the issue that always occur when the process of the matrimonial property division? The practice of dividing matrimonial property is often associated with unfairness to the claiming parties due to the non-clarity of the existing provision in providing appropriate and fair methods. The current provision causes the court to adopt different interpretation in ascertaining allocated shares to the divorced party. This is mainly because contribution is considered as a sole criterion in dividing the assets. Other factors such as well-being of the minor dependent are often disregarded in the division of matrimonial property. Inconsistency of court decision can be observed from a few decided cases. The main reason for the inconsistencies is due to the absence of specific detailed provision in the law. Besides, there are also differences interpretation of court in defining the matrimonial property following the Islamic family state of enactment. However, the provision of matrimonial property stated in various states have common principles where the contribution of the husband and wife, either in terms of capital or joint effort, are factors to determine whether the property acquired is harta sepencarian, as well as to decide on the proportion. So now let's move on to the factors that was considered during matrimonial property division process. So some studies has identified several factors that are considered by the court in determining the matrimonial property to be divided among the divorced spouses. Among the factors are extent of direct contribution by money, property, and work. Apart from that, the indirect contributions of a homemaker, debts for joint benefits, as well as the needs of minor children were also examined in determining the assets division. In general, direct contributions refers to a contribution of any party of the divorced spouse to acquire the disputable matrimonial assets, either the contributions in the form of money, property, or labor. Monetary contribution is considered as direct contribution when it is used to cover the payment needed in acquiring the property, either to cover the total price or some of the amount needed. It also refers to any payment made for improvement of property, such as to cover the cost of renovation and construction of the home that certainly increases the value of the assets. Besides monetary contributions, analysis shows that the court also recognized contribution made in the form of property as direct contribution. A party can acquire the asset by making property contributions. For example, a wife traded in a car as part payment of a new car with the remaining price paid by the husband. The court regards such contribution in the division of assets. The contribution of the homemaker has been significantly addressed in the distribution of matrimonial assets. In dividing sole effort assets, the homemaker's right to appropriate amount of matrimonial property is recognized for her service to take care of the family. It has been observed that the extent of homemaking contribution is confined to her physical efforts to serve her family as a wife and mother in taking care of the husband and the family. In division of matrimonial asset, the court adopts literal interpretation, which requires the court to strictly follow the provision. However, in some conditions, the court uses discretion to decide what it thinks appropriate to arrive at a fair and just division. The discussion below highlights circumstances where the discretion of the judge is used in the division of assets. Literal interpretation of Section 122 1 of Islamic Family Law Enactment requires the court to mainly consider monetary contribution for division of joint account assets and disregard the indirect contribution in determining the share. Fair and transparency are very important in every process of solving the issue of property, and we need to solve it according to Shariah law. That's all from our group. Thank you.